And we go everywhere. Our clients come from everywhere, so we get to see a lot of the people all over the country. And a lot of these arbitrators are just fine individuals. Most of them are retired judges. People said I was a trial lawyer, a trial judge for 25 years. We have several of them in Philadelphia, for example. People who have a legitimate interest in doing the right thing. People who are really giving their time and their effort, who are very involved in the whole arbitration process. See, at AAA, they get paid, at the American Arbitration Association, instead of getting $400 a day, they get $400 an hour. So your typical NASD case might cost $2,000 or $3,000 for, let's say, 3 days of hearing at $400 a day per arbitrator. At AAA, that could cost you $50,000 to $100,000 because those folks get paid $400 generally, between $300 and $500 an hour. So NASD arbitration is much less expensive. But then you have the people who sit on panels, and you got to be a little skeptical of them because they're ones that, by definition, like to sit in judgment of others. The reason they're serving in arbitration now, not because they're trying to do the right thing, not because they're public-minded. No, they're frustrated, wannabe judges. They get power from being a judge and being in that position. Even when the parties, for example, might consent to a continuance to accommodate, a lawyer's schedule, to accommodate a witness, for whatever reason, maybe the parties are talking settlement. They want to ask the panel, by consent, both parties agree to a continuance. But the arbitrators, who are supposed to serve at your leisure, they're there for the parties, say, no continuance here, folks. There is no continuance because we're in a hurry to sit in judgment of others. We're so eager beaver that we want to decide this case, and you can actually feel it that these folks, and a lot of them have been removed, they actually enjoy playing judge. And then you have ones that are just, they don't care, they don't do their work, they don't read the pleadings, they fall asleep. We had one that was 93 years old recently. The poor guy just died. But we had a hearing with him just before he was 92. And he couldn't even read the script. He couldn't even read the arbitrator's script. The staff attorney came up from Washington to help him read it. And I said to our staff attorney, who I know very well from Washington, I said, look, why is this guy even here? He said, well, we can't remove him. Unless he wants to step down by himself, we have no basis to remove him simply because he's 93 years old. But you have a lot of that going on too.
Excuse me, not to interrupt, you talk about arbitrators now. Maybe you could spend a very brief moment talking about certain client problems. An example might be what happened to us in Chicago. Or something else that comes into your head.
Yeah, I mean, we can talk about client problems too. I mean, again, what kind of claims are you bringing against these stockbrokers? And the client problems come up because it comes up in discovery. You read all day, you folks have in your case books about, when I study securities law, the private cause of action is 10b-5 create a private right. There's a private right of action. And, there's been a lot of cases that have come through the courts where, a violation of the NASD suitability rule, now Rule 2310, does that create a cause of action? And the court said, oh no, violation of the, self-regulatory rule, like the duty to only sell suitable investments, that's not actionable. Failure to supervise, well, that's not actionable either. That's a violation of, the NASD Code, Section 27, 3310, the duty to supervise. Hey, those are just self-regulatory rules. That's not fraud. And I try to get you folks to read some of the cases that really deal with that, because the way these cases have really come under the penumbra of 10b-5 is that it's an omission. I forgot to tell you that the broker you bought the securities from was unsupervised. I forgot to tell you by way of omission that the securities I'm selling you are very risky, and we're disclosing all the risk that's attended with the ownership of those securities. So basically, all the cases that we bring claims on behalf of customers, they fall into certain categories. They fall into, let's say, I have 7 categories, not including the sale of unregistered securities. And they're all pretty much cognizable as violations of 10b-5 by omission. They also are common law fraud. They also, in a substantial part, are breach of fiduciary duty where the broker acts. They are fiduciaries. They act in the interest of the client, as they're supposed to act in the interest of the client, not their own interests. And there's been a lot of law on that. I think it was the Second Circuit came down in the Kalinowski case back in 2002, which said that the broker really has no duty to provide ongoing investment advice. So once the broker sells you Cisco systems, the duty ends right there.